Hello, my name is Rodolphe Rouffier, and I am an associate in the International Arbitration Group at Clifford Chance in Perth. I am here with Sam Lottrell, a partner specializing in cross-border disputes. Hi, Sam.
Hello, Rodolphe.
Today, we will talk about cross-cultural impacts in mediation and some of the non-commercial factors that bear on the mediation process. Sam, first question. What do you see as the main cultural impacts in mediation?
Well, I think there are two main levels of cultural impact on mediation. I think there are cultural impacts upon or aspects of the mediation procedure, and I think there are cultural aspects of and impacts on the mediation participants. And by participants, I mean everybody. I mean the disputing parties, their lawyers, and the mediator they have selected to assist them in the resolution of their dispute. Now, on the process, I think it's important to note at the outset that, being frank, mediation as we know it is in many ways, if not most ways, an Anglo-Saxon device. We need to recognise that. Mediation's success in the Anglo-American world, in the English-speaking world, shows its cultural origins. And those cultural origins, they are both cultural in the pure sense, the societal sense, and they are cultural in the legal sense, the sense of legal tradition. Now, mediation is an established part of Australian legal culture too, very much so. But we I think, do it in often quite an old-fashioned way in some senses, relative to the way it's done in other countries. I think in Australia, and this is true of other common law jurisdictions, but I think in Australia in particular, our approach to mediation and the mediation culture that we have developed is very personalised, especially in commercial disputes. I think really, in my experience, and it's just my experience, but I've done a fair bit of mediation. In my experience, mediation, often really means bringing in a powerful QC that everybody respects, so that the lawyers are on their best behaviour while their clients talk sense. I think that is how it goes quite a lot of the time. It's not a bad thing, it's just the way it is. The point I'm making is that culturally, in Australia, commercial mediation is often almost entirely geared around one cultural driver, and that is the respect that all of the parties' lawyers have for the QC that they've brought in. And so I think we need to understand that culturally the process varies significantly, and even within the group of common law jurisdictions, there is significant variation. I know it's very different. I've been involved in mediations in Europe, but it's very different there. And Rodolphe, you're a French lawyer. Perhaps you could offer us your perspective on mediation in France.
Right, Sam. Well, you see, it is very interesting to talk about France in the context of mediation, because it is a relatively new tool for not only the lawyers in that jurisdiction, but also their parties. Traditionally, there would either be negotiations, and if they're successful, that would yield an agreement that could be ratified by the judge. Or if the parties could not agree through those negotiations, then they would just litigate. And there was no compromise between negotiation on the one hand and the court process on the other. Now, interestingly, France has been influenced a lot by what has been happening in the common law world and in particular, in fact, the US. In the US, as you know, Sam, mediation is the bread and butter of dispute lawyers. It has an extraordinary rate of success, including in commercial contexts. Whereas in France, until very recently, mediation was used mostly in the realm of family law. So we see that shift gradually toward the commercial business world. Another factor of the popularity or the growing popularity of mediation in France is the influence of, well, international businesses, international law firms, and in fact, international arbitration. So when you think about mediation in France, for instance, you need to bear in mind that the French parties involved in the process might not be as sophisticated or used to mediating as, say, Australian or American parties. And frankly, it is the lawyer's job to educate their clients about those cultural differences. Now, Sam, we have talked about France, but maybe you can tell us also about Germany and Switzerland.
Well, yes, and I think there's a big difference, within the European legal traditions. There's a big difference between the French tradition and the Germanic tradition. In my experience, I've been involved in mediations in Germany and Switzerland, and I've been involved in a lot of arbitrations with German and Swiss arbitrators. So I've had some experience with those traditions, including in the specific mediation context. My take on it is that what Germans consider to be mediation, we would probably, if not certainly, call true conciliation, and potentially even quite hardcore conciliation, quite formal conciliation. There is a long-standing tradition of mediation in Germany, and certainly in the German-speaking cantons of Switzerland. Now, the tradition is different. It is quite different to our mediation tradition, but it is very well established. One of the reasons it's very well established is that it's entrenched in their codes of civil procedure. So in the case of the German Code of Civil Procedure, for example, the court is required to keep the prospect of amicable settlement in its mind as it judges the case. And much like in Australia, there are mandatory mediation and in conciliation in some cases, steps that need to be completed before a matter can be submitted to adjudication by a judge. And in the German Code of Civil Procedure, Article 278, Article 278(1) requires that in all circumstances the court is to act in the interests of arriving at an amicable resolution of the legal dispute or of the individual points at issue. And Article 278(2) provides that for the purposes of arriving at an amicable resolution of the legal dispute, the hearing shall be preceded by a conciliation hearing unless efforts to come to an agreement have already been made before an alternative dispute resolution entity, or unless the conciliation hearing obviously does not hold out any prospects of success. In the conciliation hearing, the court is to discuss with the parties circumstances and facts, as well as the status of the dispute thus far, assessing all circumstances without any restrictions and asking any questions wherever required. Now, that is a fairly powerful mandate for a court. It is a mandate to act in the capacity of a conciliator or a conciliation body on an interventionist and unrestricted basis. If you are a lawyer in Germany and you have been trained in that tradition and you work in the courts, you will have been in a lot of conciliations. Now, that is a very formal type of mediation, but it is still on the mediation spectrum. So the German tradition of mediation or conciliation is very, very strong, and they are used to it. If you've got German parties or German lawyers in a dispute, you need to be aware of that. Now, moving across the globe, more into our region, in Asia, it's well known that mediation is an integral part of the dispute resolution systems in many Asian cultures and legal traditions, and it's certainly deeply embedded in North Asia and North Asian cultures. In my experience, and these are generalizations, but it's impossible to discuss culture without generalization. In my experience, Asian parties are often quite at home in the mediation context. I've seen that or got that impression in cases involving Japanese parties and Chinese parties especially. I think one of the reasons Asian parties seem to prefer mediation is that they often have an aversion to litigation. Now, that is, in my experience, certainly true of Japanese parties. I'm the first to acknowledge that there are significant differences in the way different Asian cultures and states view litigation. Some Asian cultures are actually quite litigious. In Korea is quite a litigious Asian culture, for example. The Chinese are more interested, I think, and more inclined to litigation than perhaps we in the Western world consider. So I think there is a lot of culture around mediation in Asia. But Rodolphe, I'm conscious of the time that you've spent in China and including in Taiwan. What experiences and observations would you relate?
Well, I would say first of all that China, like other civil law, continental law jurisdictions, has a different approach to mediation to common law parties. That's for sure. The tradition there is also focused on the active role of the mediator or conciliator in effect in the process. That is due not only to their legal tradition and culture, but also due to their social culture, the Confucian culture, and the notions of harmony that preside at Chinese society. There is a strong sense of respect of adjudicators, and I would say that what Chinese parties expect from dispute resolution is just that, to resolve the dispute by any means possible. That means, of course, negotiations, but also mediation, conciliation, arbitration. I think Chinese parties have a very holistic approach to dispute resolution, and they're open to any means by which they could basically put an end to their dispute. With that in mind, Chinese parties are usually very comfortable to or amenable to having the mediator act also as the arbitrator and vice versa. This is apparent in their own arbitration law in China, where it is expressly stated that an arbitrator may also act as a mediator in the same case with the same parties in the same agreement, as long as, of course, the parties themselves agree to the arbitrators endorsing that role. Now, another aspect to mediation in China, and that is quite specific to the Chinese culture, is also the view that deal-making can be better harnessed in mediation than in litigation or arbitration.
It's an interesting point, isn't it? Because the way different cultures approach deal making is clearly a major factor when it comes to mediation. Some cultures have a long-standing tradition of deal making, and other cultures, the kind of mercantile culture and the celebration of mercantile culture is relatively young. Certainly in European culture, it was only relatively recently that mercantile activity came to be given a high place in society. You remember, it wasn't that long ago that that business and commerce were considered to be vulgar by the aristocracy in many European countries and in England. So the culture of deal making is really important, and I think that if deal making is considered virtuous in the culture concerned, then that's going to play well for the mediation. So we do need to be aware of all these factors, and in my experience, they can really matter. There is a strong element of culture in the mediation process itself, and there's a strong element of culture in the parties, wherever they are from, even if you think they're not culturally different. There are still cultures to be considered there, and that might be at the level of business culture, which we'll come back to.
All right. So now turning to the participants themselves to the mediation, what about the cultural aspects in them? And by participants, I mean the disputing parties, the lawyers, and also the mediator.
Yes, and I think this is probably the way most people would view the issue of culture in the mediation context. That it's more in personam, it's about the participants themselves rather than the process they're in. And what we've just discussed is that the cultural question has a procedural aspect, but in the personal sense of the participants, I think it's quite it's fascinating. It's necessarily a diverse field. We do need to think carefully about culture when we consider the utility of mediation and how we will approach mediation if we're going to go down that path. And I think the most obvious practical impact of culture on mediation is language. If the parties don't speak the same language, they're going to need help to communicate. And that sounds obvious, but it really does need to be thought about in advance. It's not enough to say, oh, we'll get a translator. Some cultures and languages just don't translate. And we had a case recently where we learnt that a very, very difficult translation required, and there were many parts of the case where the language concerned just didn't translate to English. So don't think of this as something a translator can fix. A very good translator will be able to do quite a lot. And some languages translate well. French translates well to English, and many other languages have common roots that make them fully translatable. But there are many languages that have absolutely nothing in common, right down to grammar and the entire approach to expression. And we need to be aware of that. So the translator, if you're going to use one, needs to be very good, and they have to, in my view, have done a mediation before, because it's very fast moving. It's not like court. It's not like translating a witness's evidence on the stand. It is a discussion where the translator has to be fully immersed and involved. And the nature of a productive mediation is that people aren't really going to wait for translation like they would in a court or in an arbitration. So if you're going to use a translation, you need someone who really knows what they're doing. That means you're going to need a commercial translator. You are not getting a court translator for this work. You're getting a translator who would be used by big businesses in big business negotiations. That's the first point. And I think I think that we do also need to realise that some translations will never be right, and mediation, if it's productive, will move fairly quickly. The risk of things being lost in translation is real, and the best control on that risk is to put things in writing. So if you have two parties who speak different languages, very different languages, and come from very different cultures, in my view, there is a stronger case for a written component in the procedure. Position statements, maybe even short written responses, so you can clearly set out your needs and wants and get a clear position from your counterparty. That should map the discussion in a way that makes it certain you are on the same page. So I think there is a strong case for a written component in a mediation where the parties are from very different cultures, speaking very different languages. I think there are, of course, the classical aspects of culture that you need to be sensitive to. The real question in mediation, in the classical culture or truly cultural sense, is what are the social norms and customs that you and the other participants will need to abide by? Is the counterparty or are the parties firstly radically different in their views of things like hierarchy? Is one side very hierarchical, as is true of organisations from Asian cultures, for example? They're often quite hierarchical. Is one side flat or radically less hierarchical than the other side? To put it in practical context, if one side's flat and they come to a mediation with a big delegation, and the other side's hierarchical and they come with a delegation, and the flat delegation may well have lots of people speaking at the same time, whereas the hierarchical delegation will have one senior person who does the talking and everyone else just sits there. Now, neither approach is wrong, and neither approach is better than the other. They're just different, and you need to be aware of that, because that, even in that practical sense, will shape the procedure and the way the parties interact. The other major question is how do the parties communicate? What is a normal mode of communication in the cultures concerned? And are they direct in the way they communicate? And that it's often thought that Northern European cultures and Americans are quite direct in the way they communicate. Australians are often quite direct, but also often not necessarily direct. The differences in the way people express themselves are really important, because if you are dealing with cultures that are direct, you are going to move faster. That's the reality. Another question is, culturally, are the parties, emotional? Is one of the parties from a culture where it is considered normal or acceptable to be emotional, even in, for example, a business context? Certainly, some cultures are regarded as more emotional than others. For example, in Asia, it's sometimes thought that people, are not culturally very emotional. That's not my experience. I think that a number of Asian cultures are quite emotional in a business context. Indonesian people can be quite emotional. Indian people can be quite emotional. Australian people can be quite emotional. And certainly there are other cultures where emotion is less common, and even cultures where emotion is displays of emotion are regarded as shows of weakness, and the classic example of that is Russia. Now, what you need to think about is how much emotion is likely to come out, and how will the parties react to displays of emotion. you don't want to get into a situation where a display of emotion is a crescendo when it shouldn't be. You don't want a situation where people are misreading displays of emotion. And for a mediator, that's really important, because the mediator needs to be aware of what a display of emotion might mean culturally. It might not be anger. It might not represent the parties having reached a point of no return. It might not be a fork in the road. It might just be what people from that culture do in that situation. And it's really important to recognise that. And then I think, finally, there's the cultural aspects of the parties' particular organisations as businesses. This can be a very significant factor. You need to think about how each party as a business makes decisions. Do they make decisions in a vertical fashion from above, almost by decree? Or do they decide in a more horizontal manner with delegated decision making and more structured decision making processes, where some things can be decided fairly low down in the organisation, and there's a sort of system for escalation. You need to think about that in the context of the dispute, because if there's an escalation threshold, if for example, one party, they've got representatives at the mediation who can decide an issue when it's worth no more than $50 million, but above $50 million they have to get board approval. If you want to do it quick, obviously you're going to be trying to get a settlement at $49 million, or right at the threshold. You don't want unnecessary process internally around any settlement, and that's a factor. Of course, it's about time there. Mostly, it'll take longer to get a settlement done if there's a lot of process around the decision making internally. But also remember that the more people you bring into a deal, the weaker it gets in many ways. If you've got a settlement and you do a deal in principle at a mediation, and then it has to go back to the boards of the companies concerned, you can't predict the response of the board. So there is risk in the internal processes of the participants, and that is business culture. You need to understand it. I think also, we need to think a little bit about familiarity with mediation in the internal sense. How would the business representatives, how would they explain mediation to their management? Is it alien to them? Are they familiar with it? What's their point of reference culturally? And that's important. And Rodolphe, do you have any observations to make there?
Well, I was thinking of asking you, because we work a lot with governments at Clifford Chance. Would you say that these considerations having to do with business culture also apply to governments when government states are themselves involved in a mediation process?
Yeah, I think that governments as participants in dispute resolution processes present a range of challenges, including the challenges of different political cultures. Certainly, the expecting a government to commit to a binding course of action, on a given day, in the way a mobile or nimble business would, is unrealistic. You need, in circumstances of a dispute involving a government, you need to be aware of government processes and the authority that is needed to commit a government to any settlement or any course of action. So yes, I think governments present unique challenges and raise cultural issues that we really need to think carefully about. And we, as you sort of indicated, we do see that a lot in our cases, acting for investors against foreign governments. But it's also culture. The cultural aspect, I think, is also very, very important when you get to the lawyers. And we tend to have a fair idea of the cultural differences between lawyers from different jurisdictions. I think that for the most part we're pretty well informed of the differences between lawyers from other countries. We know the main differences, but we do tend to be, I think, a bit superficial in our understanding of the legal cultural differences and their potential impact on mediation. And Anglo-Saxons tend to see mediators as conduits for a negotiated outcome. It's that conduit function that we tend to associate a mediator with. We also tend to see as a relation to that conduit function, we tend to see a calming role played by a mediator. I used the example, I gave you my opinion earlier, that often mediation in Australia is about getting a powerful QC in who keep the lawyers on their best behaviour. That's about calming the setting so that sense can prevail. So I think we as Anglo-Saxon lawyers, or lawyers from Anglo-Saxon jurisdictions and traditions, see mediators quite differently to the way practitioners from other jurisdictions do. Civil law practitioners tend to see mediators almost as soft judges, and we saw earlier the system in Germany mandates the court to assume a conciliator role. That's very interesting from a comparative law perspective. But think about it from the perspective of how lawyers who are raised in that environment might approach a mediation with a party from, say, Australia or Singapore. It's going to be different. There's different expectations and different understandings of what the mediator should do and will do. So we need to be aware of that. I think the basic difference in view of common law and civil law practitioners is really attributable to the fundamental difference between common law and civil law approaches to justice. We all know common law justice is adversarial, and civil law justice is inquisitorial. But think about that for a minute. That is a fundamental difference. In a civil law system, the judge asks the questions and conducts the process. In a common law system, the judge is more likely to be sitting back and letting the parties shape the process through the arguments they raise, the claims they make, the defences they present, the witnesses that they put on, the questions they ask. So it is a really different procedure. And in an inquisitorial procedure, where the as you find in European legal systems, the civil law mediation approach is different as well. Civil law mediation has the flavour of conciliation because it's being practiced in a jurisdiction where the judge is much more active than he or she would be in a common law setting. So I think we do need to be aware of those differences when it comes to the lawyers, because the lawyers are really important participants in the mediation process.
Right, thank you, Sam. So we've talked about the parties, the lawyers, but in the end, what about the mediator's own culture?
Yeah, I mean, I think the mediator's own culture is really important and is going to be one of the main characteristics that the parties take into account when they're selecting a mediator. The mediator's main mission is to be neutral. And I think as part of that, one of the mediator's main missions is to understand the cultural differences of the parties to the dispute. It is hard to manage very different cultures in a contentious context. It is hard. There is a lot to it. But a good mediator will or should be able to use culture as a tool to bring the parties together and to stop them walking away. A good mediator will know where there is cultural leverage and know how to use it. And the classic examples are things like loss of face. A good mediator will know that a party who comes from a culture where loss of face is a serious thing, a good mediator will know how to shape a settlement or guide the parties into a discussion where the outcome will not result in that party losing face. Similarly, in some cultures, apologies are very significant gestures, and a good mediator will know where apology as part of a solution is going to be valuable and valued, and the mediator will understand how the apology should be expressed. These are cultural levers that mediators can pull if they know where they are. And that's why I think there is a really powerful cultural dimension to the role of a mediator in a commercial dispute.
Right, well, thank you very much, Sam. Culture definitely plays a huge fundamental role in a cross-border mediation process. Thanks again for the explanations.
Thank you, Rodolphe. Thank you, Rodolphe. Thank you, Rodolphe. Thank you, Rodolphe. Thank you, Rodolphe.